Hello everyone, and welcome to a new episode of the DBPACast. I'm Izadora Pereira, a trademark attorney at the Vice-Presidente e Associados. Today, we are diving into a fascinating area of intellectual property, non-traditional trademarks. Marks that go beyond words and logos, to include sounds, colors, motion, and in some jurisdictions, even scents. We are very excited to once again welcome our special guest from Japan, Mr. Tomoya Kurokawa of SOEI Patent Law Firm. Today, we'll compare the Brazilian and Japanese systems and learn from each other's experiences. Welcome, Mr. Kurokawa, and thank you for joining us again.
Thank you very much, Izadora. It's a pleasure to be here and to share Japan's experience on this evolving and very interesting topic.
To begin, could you give our listeners an overview of how non-traditional trademarks are treated under Japanese law?
Of course. In Japan, non-traditional trademarks are those that go beyond the conventional word and figurative marks. Since 2015, Japanese trademark law has explicitly allowed registration of sound marks, motion marks, hologram marks, color marks, and position marks. Three-dimensional marks were already allowed before that, since 1997. However, we still do not accept smell or taste marks because of the difficulties in providing a clear and consistent representation of these signs.
There are some similarities in Brazil, but Japan is ahead of non-traditional trademarks. Here, it is not yet possible to file applications for sound, motion, color, hologram, or olfactory marks with the BPTO. Position marks are already recognized, and as of November 28, 2025, applicants will also be able to seek recognition of acquired distinctiveness, that is secondary meaning. So, could you share some notable Japanese cases where non-traditional marks have been successfully registered and protected?
Yes. One good example is the registration of sound marks. Since 2015, companies have been able to protect jingles and brand sounds. For instance, the sounds used in Intel's advertisements, the famous chime, has been registered in Japan. Another case involves motion marks, where short animation sequences have been accepted. We also have some examples of registered color marks, such as combination of orange, green, red, and white, used by convenience store 7-Eleven. But these cases usually require strong evidence of acquired distinctiveness, which means proving that consumers directly associate that color with one specific company. As for color marks, unfortunately, there is no registered trademark for single color so far. For 3D marks, shape or package of product can be registered if it has acquired secondary meaning. For example, the Coca-Cola bottle shape and Hermes Birkenbark shape have been registered.
In Brazil, the BPTO has allowed few registrations for position marks. Many applications have been rejected for lack of distinctiveness. A headline example is the Labutan Red Solo. In 2024, a federal trial court in Rio de Janeiro overturned the BPTO rejection and recognized the distinctiveness of the Red Solo as a position mark. Soon, we should also see examples involving secondary meaning. As for colors, Protection is possible, provided they are arranged or combined in a distinctive manner. Sound and olfactory marks appear in the BPTO's 2023 to 2026 strategic plan, but their implementation requires a statutory amendment because Article 122 of the Brazilian Industrial Property Law limits registration to visually perceptive signs. It is possible to register the three-dimensional shape of a product, provided it's neither necessary nor commonly used in its market segment, nor essentially tied to a technical function. So, applications often need to show that the shape is not functional and that consumers recognize it as a source identifier. In both countries, the challenge is similar. Authorities are strict about distinctiveness. From your perspective, why is it important for companies, Japanese or foreign, to protect non-traditional trademarks in Japan?
In today's competitive market, brand identity is not only about a logo. It is about a whole consumer experience. The sound with which a device makes when it turns on, the shape of product or its package can make a strong impression or memory for consumers. Protecting these elements legally ensures that competitors cannot copy them and free ride on the brand's investment. For foreign companies, registering these marks in Japan is essentially important if they want to fully control how their brand is perceived in the Japanese market.
Absolutely. We are seeing the same trend in Brazil. In many sectors, the brand experience has become as important as the name itself. What are the main procedural challenges applicants face in Japan when registering non-traditional marks? And how does enforcement work once they are registered?
The biggest challenge is distinctiveness. For example, many applications for color marks are rejected because the examiner considers the color to be too common. To overcome this, companies must present strong evidence like consumer surveys or long-term use that has created secondary meaning. As for enforcement, Japanese courts are still building case law on non-traditional marks. Enforcement is possible, but judges are very cautious and require solid proof that consumers associate the mark with the brand. However, sometimes 3D trademark owners successfully enforce their registered 3D trademark rights. For example, Hermes successfully enforced its registered 3D trademark rights against competitors.
In Brazil, examiners are also strict with position marks, and applicants often need to demonstrate distinctiveness. As in the Labutan case, the BPTO initially rejected the application. The owner challenged the decision in court, obtained a favorable first instance ruling, and the case is now on appeal. So looking ahead, what do you see as the future of non-traditional trademark protection in Japan?
I believe we will continue to see more companies applying for sound, motion, and color marks, especially as marketing strategies become more immersive. Perhaps in the future, as technology advances, Japan may also revisit the possibility of protecting smell or taste marks, although technical difficulties remain.
That's a great point. In Brazil, we expect the same trajectory. Growing interest from companies, more case law, and broader discussion about expanding the categories. It's an exciting field where Japan and Brazil can continue to exchange experiences and learn from each other. Thank you so much, Mr. Kurokawa, for sharing Japan's perspective with us, and thank you to our listeners in Japan and Brazil for joining this conversation. We hope this inspires business and IP professionals to think more creatively about brand protection. And with that, we wrap up today's episode. Stay tuned for the next DBPAcast, and until then, goodbye!
Thank you, Izadora. It was a pleasure, and I look forward to more cooperation between our countries in the field of intellectual property.